Welcome, everybody. We're going to wait a few minutes like normal. We've got the splash screen up. Has our questions email address, but we'll be taking some questions tonight. So just want to welcome everybody. Normally I wait until 5 minutes is up, but since we are recording, just want you to let you know we typically get going about 5 minutes after the hour. We're here to answer questions about where we are in the bankruptcy process. The recording of this event will be on the TCC BSA website. So anything you want to know about what's going on, when the town hall is, when the next town hall is, what developments, materials that we talk about tonight, we're going to be working on getting some more materials out on tccbsa.com. And the email on the bottom of that screen is tccquestions@pszjlaw.com. So we're not here to give you any legal advice. We're at the point in this process where you need to be talking to an attorney. Please start asking questions. We have folks that are lined up to answer them. And we look forward to having the meeting start here in about 2 minutes. Evening, folks. So about 4 minutes after the hour, we're going to get started here in just another minute. And we've got an action-packed lineup tonight and a lot of material to cover. So grab your cup of coffee or your Mountain Dew or your water. And we're going to try and keep it to an hour, but we're going to put a lot of material at you. So we'll get started here in just a moment.
Just looking at some of the questions coming in, John, we're getting a lot of questions and we're going to do our best to get them answered tonight and also pull some off that we'll talk about a little bit, but we're going to really be focusing on the weeks ahead and trying to answer the most pressing questions.
Right. All right, Deb, I think we've got a pretty good group of folks. Why don't we go ahead and get going? Good evening, everybody. John Humphrey and Doug Kennedy, both co-chairs of the Tort Claimants Committee. I think in the next couple of days, we'll be celebrating our 2nd anniversary together. How about that, Doug? Long time.
Time flies when you're having fun, huh, John?
It does. So as we've told you before that, all the disclaimers, we're not attorneys. We're not going to give you legal advice. We would recommend that at this point in this process, you are talking to your attorney. We'll put up the TCC questions at pszjlaw.com, but this is probably the point that you start asking your attorney questions. So what are we here to do tonight? We're here to talk about the revised plan that we've been working diligently on since you all voted. And I want to just shout out to everybody. We're here because we got the pressure to go back and work on a deal that's substantially better for every single survivor. And, is it perfect? It's not perfect, folks, but, I don't think the word perfection follows trial, lawsuit, mediation, attorney, but it's just a good deal. And so we're here to encourage you and inform you to vote to accept it. There will be an open window for the next several weeks for you to change your vote from no to yes. And we want to give you enough information for you to have a meaningful discussion with your attorney or your advisor so that you can make that decision. Doug, any thoughts as we get started tonight?
I think we're hearing from a lot of survivors that everybody's very anxious. Everybody wants to get this to move on. A lot of questions are how much longer is this going to take? When am I going to see my money? Things like that. And, the TCC has really come to understand that this is a process and the process takes time. And we just want to be in the advocacy business. We've always been advocating for what's best for survivors, but we also want to be in the education business. And we just want to make sure that everyone has a good idea as to where we are in the process, what's going on. If we know how long it's going to take, we'll share that with people, but we just want people to be updated. And I think one of the messages tonight is going to be, we still have got to be patient as this works its way towards a confirmation process. And I will say, the TCC has talked at length about making sure that the trust understands that it is going to have to communicate with survivors as well. So we're going to communicate a bunch in the weeks ahead, and we're hoping that that's going to continue.
Great. Thanks, Doug. So we've got our group of advisors on tonight. I think you're going to hear mostly from Rich Pachulski and Jim Stang, who you've gotten to know over the last year or so. We told you when we asked you to vote no that what we wanted was a chance to go back to the negotiating table and work on youth protection, figure out how to get more money, and build an independent trust that not only was accountable independently to you all, but didn't have an axe to grind for anybody else, and was a steward of the assets that are going into the trust. And we still believe that. And so we're going to turn it over to Rich Pachulski, and he's going to go through some of those details, but I think he will echo that what we did was a lot of yeoman's work to put a really good deal together. And, it was tough for both sides, but we're all pulling on the same rope now. And now we got to go through the confirmation process. So Rich, I'd like to turn it over to you.
Thanks so much, John. Thank you, Doug. I want to start with first, a thank you to everybody who voted no. I know you got pushed by different sides of the issue, but I don't believe that we would have ever come even close to the deal that was ultimately cut without the no votes. So for that, I can't thank everybody enough. But I also want to say something else. We have said on a number of town halls, both before I got involved and after, that we were very focused on three legs of the stool. One was fair compensation for the survivors. Second, we discussed was an independent and fair trust. And the third, which was also absolutely critical, was a transparent and thoughtful youth protection program. And if we didn't get any one of those three, we were never going to go forward. But the other thing I want to make really, really clear, because I, for instance, and Jim Stang and others were in negotiations for the last several weeks after the vote came in no, and we attended probably 15 round-the-clock mediation sessions. We did not make a deal because we felt we had to make a deal. We did not make a deal because we felt we had to take the best deal we could get. If we could not get what we thought was a very favorable deal on the three issues that I outlined, we would have walked and we would have opposed the plan. I can't make that clearer. And so we're coming here today, as John said, not that this is the best possible plan. I don't know, I've done this for 42 years. I'm not sure there is such a thing as the best possible plan. But considering the circumstances of Chapter 11, the time it's taken, and most importantly, the desire to get the survivors significant and compensation as quickly as possible and deal with that through a trust and make sure the Boy Scouts in the future have a fair youth protection program, I think we've done as well as could possibly be, even if we had started earlier. So I want us to start with that. And then what I'm going to do is go over the two of the legs of the stool, which is the compensation issue and the trust, and then turn it over to my partner, Jim Stang, who is going to spend time discussing the youth protection issues. So let me spend some time, and some of this is going to be at a high level. And we're going to have more town halls to get into more of a more of the pathway to get the confirmation. But as I've said, we had 3 goals: the pathway to more value, higher compensation; second, independent trust; and the third, the meaningful youth protection measures. That's what we looked at. So in the first, which is the value and distribution, we right now in the trust for the benefit of the TDP program is approximately $2.7 billion. Now, we believe there are at the time that we began the negotiation, there were a couple of things we believed in: that we could not allow the negotiations to continue on to get low dollars from either charters or from the insurance companies. The charters had received significant releases that we did not agree with, and we had to narrow those releases. So we came up with a pathway that, though there were some settlements in place, including with the Methodists and the TCJC, for instance, that there could be no more negotiation or settlements. We would negotiate, but not settlements, with the non-settling charters or people who had not put in real money. And so that was an issue, even though the plan, as now projected, would have given them releases. So what did we do? We insisted, as part of any settlement, that through the effective date, the TCC, and there are others, but the TCC has veto rights over future settlements through the effective date of the plan. If we don't like the number, it's vetoed, as compared to what happened before, as there were settlements that were included without us. After the plan is approved, the settlements requires the trustee to approve it, who will be an independent party, as I will describe shortly, and the advisory committee of 7 members have to approve it. And so that is critical, whereas before, our concern was that there would be settlements that would be unfavorable even before there was an effective date, before the plan went into effect. And now that will not happen. Now, we also had to deal with the fairness of the claims. And as I said, there's $2.7 billion right now that goes to the TDP. Now, the TDP will also be administered by a claims administrator who is an independent party, who is not controlled by anybody. The TDP has 3 levels of potential review. The first level will be done by a neutral who will review it. But if you're dissatisfied, you can go to a second review. That second review will cost $1,000, not insignificant, but there has to be a cost because of the time commitment. And there will be a second review. If you're still dissatisfied, there is a third option, which is simply to say you're dissatisfied and you want to litigate in court as to what an appropriate TDP would be for you. Now, many of you have then heard of this concept of an independent review. The independent review is, frankly, separate in many respects from the TDP. The independent review, and is dealt with because that is the best mechanism to get to the excess insurance. The vast majority of claims cannot get to the excess insurance. At this moment, will be a second pot for the independent review. To be frank, there is nothing in that pot because not a single excess insurer has settled to date. So there is a risk if you decide to go into independent review. Now, there's been a lot of discussion that there's a cost to that. The cost is $10,000 to initiate the review and another $10,000 when the review begins. Now, why is that? The independent review, as compared to the TDP, is the equivalent of a mini trial. People have to sit for their depositions. There may be the need for experts. There may be an insurance company that will oppose it. So it is a mini trial, of which, frankly, there have not been that many against the Boy Scouts. Most of those have been settled. But this is a mini trial. It will cost. And one of the things that we thought would be unfair is if people went into independent review so that they can seek to go after the excess insurance, and the people who remained in the TDP would pay for that. That said, if there's a party who wants to go into independent review and believes that the cost is a problem, then that party can seek a waiver of the first fee or some partial waiver of the first fee from the trustee. So we've tried to come up with a fair mechanism, but also to be very, very clear. This is complicated and we know it, and it's also relatively new. And so we intend to put materials on the TCC website, which will include a video that explains this in a lot more detail, because we do not want, there's been a lot of confusion and misinformation, and we do not want that to continue. So we will address that at future town halls, and most specifically in a video and additional materials. So hopefully that will be helpful. The next issue is, there's been a lot that we said at prior town halls about the need for an independent trust governance. We cannot have trustees that have relationships with parties in this case. It will not be transparent as it should be, and it's critical that we do that. And so one of the things we insisted on was that there would be a settlement trustee who would have no ties to the Boy Scouts, to the local councils, to the charters, to insurance companies, and or the plaintiff's attorneys, so that that person would be independent, that there would be no question about the integrity of the system. There was also a requirement that the claims administrators at the end of the day would be experienced in the, particularly in the evaluation and settlement of claims, and that those claims administrators, like the settlement trustee, would also be independent and not have ties to any of those parties. And we also felt to have a real balance on the advisory committee, that there would be 3 members selected by the coalition, 3 members selected by the TCC, and frankly, 1 member who would be selected by another group who was opposing the plan, who we worked in hand through the mediation process. So we are excited about both the compensation and the trust structure, which in both cases are dramatically better than what we had before. And at this point, I would turn it over to Jim to discuss the youth protection program and how that will go forward.
Thank you, Rich. Doug Kennedy and I, with the assistance of all the other committee members, led the discussion with the Boy Scouts, the charters, and members of the coalition on how to improve the Boy Scout Youth Protection Program. And I know people sometimes wonder, why are you so interested in youth protection? The people who are the constituency of the TCC are adults. They suffered the harm already. Well, there's a belief that the greatest form of charity is giving anonymously. People don't know who you are. Well, if these protections are enforced, you will be protecting people you will never meet. You will be protecting a generation that's not born yet. That is one of the highest forms of giving. And so there will be compensation to you, but if this plan is approved, and if the youth protection program is implemented the way survivors have the ability to influence it, you will be making a contribution for untold thousands and thousands of kids. So that's what motivates me, Doug, John, and the other 7 members of the committee to keep this as a focus. A stool needs 3 legs. We were prepared to walk out of that mediation if we didn't have this. For all the money that people talk about is in that settlement trust and what will be added, we were going to walk out if this wasn't done. So the first component of the youth protection programs is something that Doug really wanted, which was a change in the culture, a change in the institution. We could sit down and talk about, we don't like this particular policy, get rid of the 72-hour no registration policy, but there had to be something done to the Boy Scouts as an institution that was going to protect kids. And the first thing that we got was an agreement to hire a youth protection executive. And there is a deadline for doing that. And a group called the Youth Protection Committee is going to be part of the process of retaining that executive. Now, they had an executive. You might remember Michael Johnson making statements about youth protection. He's no longer with the Boy Scouts. The Boy Scout plan didn't contemplate when a youth protection executive position would be filled, because it's been sitting empty for some time. There's going to be a youth protection committee. It's going to be made up of a lot of people from different groups, but half the membership has to be made up of survivors nominated by the TCC and the coalition.
And Jim, let me interrupt for 1 second. We've heard from a number of survivors that have said, how can I get involved in some of these things? And the details on that are still to be worked out. When we figure that out, we'll sure communicate that.
Absolutely. We want people who have, look, all of you suffered. All of you are able to say, if this had changed, this would not have happened to me. We need people who have the time commitment and the ability to affect institutional change at the Boy Scouts. Very importantly, a survivor seat will be on the BSA's National Executive Board, something that's never been done before in the Boy Scouts. The BSA and the Ad Hoc Local Council will recommend that a like position be created on local council boards. And the last one may sound like it's not all that institutional, but the inspiration for this came from, for me, the Diocese of Davenport, which went through Chapter 11. And when you walk up to their headquarters, there is a memorial to children who were abused. So we have negotiated for the installation of, it's called a place of remembrance, for child sexual abuse at every high adventure facility, not out in the woods somewhere, but in a prominent place where everyone who comes to that facility will see it and have a chance to reflect on how important it is to protect children. Now let's go to the next slide. So one of the things that Doug was very concerned about was, how do people find the protection materials? And if you want to go to the website, where would you find them? If you were entering scouting, how would you know where all these different threads are? So it was very important to us that the youth protection program be consolidated into a manual for adults and a manual for kids. So that's point number one. Point number two was, needed to have an organization that was independent and expert in how to evaluate programs and advise the youth protection executive. Importantly, the Youth Protection Committee will participate in the selection of that organization. Really critical. This is another way survivors has an input on how to change BSA's youth protection program. The other thing that was really important to us was that people understand what the BSA was doing and what it wasn't doing. And so the organization's evaluation of the program would be provided to the Protection Committee and the local council executive committee, not just what the organization was recommending and what the BSA accepted, but what the BSA rejected and why, so that there could be accountability for why the organization's recommendations were not going to be accepted. The Boy Scouts have committed to having a month each year designated as the period for emphasizing the importance of youth protection, with the development of appropriate materials to be used during that special month of focus. And the last point is something that Doug remembered, that at one time the Boy Scouts had a program that was not just for the Boy Scouts, but for other youth service organizations. One of our goals here is to make the Boy Scouts the platinum standard for youth protection, but to share its experience with other youth service organizations. And the last bullet point talks about a biannual meeting to do just that. This is not just for the protection of kids and Boy Scouts. This is a program for protecting kids all over the country. All of you may have known this, but I'll say it because sometimes I repeat what doesn't need to be repeated. The crimes against children are the most unreported crimes in the United States. The most underreported crime in the United States. The Boy Scouts should take leadership, and we think through this program can take leadership in protecting children all over the country. And the last slide, I'm going to ask Doug to take the lead on.
Sure, thanks, Jim. And I hope people start to see one of the reasons we are so fortunate to have Jim on board. He has dedicated his career to the protection of youth and has been instrumental in this process, letting us know what's happened in other bankruptcies in other areas as well. One of the things that we heard loud and clear from survivors from the very beginning was there needs to be the release of these IV files. And we went into this agreeing 100%. There are these files, some of which are already available. They're in redacted form, they're available online, but there were other files. And we said these have to see the light of day. As the TCC started to dig into this more and more, we realized it isn't that easy. It's difficult for me to talk about as a survivor because I'm also not an attorney. There are a lot of issues this related to privacy, related to legalities, and it's a bitter pill to swallow. So as we started to get into this and realized that it isn't as simple as saying opening up the filing cabinet and start putting these online, what we realized was a process was going to have to be put into place that was going to allow us all to have some assurance that we're working towards a time when these can get released. Okay, so I think one of the takeaways from survivors could be, wait a minute, the files aren't getting released. That's a huge failure. Well, it isn't, because we've set into place a process that's going to allow those to see the light of the day and the court to get involved. I'm going to ask Jim to talk about the kind of the legal side of this and what that means in practical terms.
Well, just before I do that, one of the things that we are really focused on in this town hall and in subsequent town halls is, why should I change my vote? Why should I change my no vote to a yes vote? The plan that you voted on did not have the ability, anyone, to have the ability to go to court and compel the publication of the relevant ineligible volunteer files. It was a promise to come up with some kind of effort to work to get it done. What the committee has done here, both in this context and in the other context, is put some teeth into the will consider, maybe we shall, but we'll see. What we really changed was the conversation was not you'll think about it, but you will do it. And this is probably one of the most important of the you will do it's. So the IV files consisted of information that covered a host of conduct. It wasn't just sexual abuse. And so saying, well, open up the cabinet and just start publishing this stuff will involve publication of information that, frankly, isn't really necessarily about the protection of kids. And to the extent that it is about sexual abuse, obviously we want to make sure that the names of survivors are protected and that your privacy is protected. But we also need to make sure that no one is exposed to lawsuits, to unfair allegations of misconduct. And so other courts that have compelled the production of portions of the IV files have required redactions and reviews. That is, in our opinion, appropriate. And so what we have done is given the Boy Scouts and the Youth Protection Executive and the Youth Protection Committee a year to work through so that we have files that can be produced that protect children without sacrificing the rights of people who shouldn't be the subject of a published report. So if that can't get done within a year, the settlement trustee will have the right to ask the bankruptcy court to order it. So it really was a recognition of the reality of what these files are and how best to use them for the protection of kids. I will just say that if you want to know where those files are that have been published, simply go to your browser and type in Los Angeles Times, Boy Scouts of America files, and you'll come up to an archive on the LA Times that has it. Now, there are other websites that have them. Some of your lawyers may have them on their websites, but the LA Times one is the one that I go to when I'm looking to see something from an eligible volunteer file. Okay, Doug, back to you.
So, yeah, let me wrap that slide up a little bit. If you go back up there for a second, Deb. The other two pieces of this that are critically important is that we wanted to make sure that people were informed if there were issues of abuse, if people were placed on the IV file. So what we have now is a system where if people are involved in that troop, they're going to be informed. But also parents of prospective scouts are going to have the opportunity, a protocol is being developed so that if you're thinking about putting your children into scouts, then you can call up and see what if there's been any issues in the last 2 years. So this is really, again, an effort to have a culture that really is sensitive and is focused on protection of youth, and it running through every thread from the top through the local council down to the individual troop. There be transparency and also outside review of this as well. One of the things that we've done is we have put together, if you want to scroll down, Deb, for a couple examples, we put together some charts showing the comparison. And again, one of the reasons we want you to support the new plan, just what the old plan is and the new plan. And we put this together in a file. It's going to be up on the website if it isn't already, and you're going to be able to look at that in detail. Last thing I want to say, and this is important, that is, Jim mentioned me, and I would really be remiss if I didn't also mention the work that was put into this by survivors from the coalition's working group, had a great deal of input on this. Also survivors that contacted us and said, this is critically important to me, here are my suggestions. Members of the TCC that all weighed in on this. And I have to tell you, we took so much strength from the number of survivors that said what Jim alluded to in the beginning, and that is, I might not see much money out of this, but I want to be sure that children are safe moving forward. So that really gave us a lot of strength, and we think that we're in a much better place. And I even want to point out that the Scouts had to make a lot of hard decisions on this. And at the end of the day, we really appreciate the support for everything that wanted to be accomplished. And we think this is going to change the culture and be a huge asset and a great reason why if we can get this plan passed, there will be significant changes in scouting to keep youth safe. So we're throwing it back to you, John.
I've been on Zoom for 2 years now. You'd think I'd learn to turn off my my mute.
Sorry.
But I was just about to say, John Lucas, could you tell us how our votes get changed? How do we actually do that if we want to?
Thank you, guys. Hey, sort of changing your vote is really no different than the way that you initially submitted your vote. So let's start with those of you who are represented by council. Most of you that are represented by council had your vote tallied or sort of collected, if you will, through your council by a master ballot. And you communicated with your attorney and you told your attorney, I want to accept or I want to reject. And your attorney took that instruction, marked it on the master ballot, and sent it into Omni or the voting agent. And all of that's still the same. And so we encourage everybody to do that now, to change your vote. And as it's obvious here, we're encouraging everybody to vote to accept the plan and to make that change. And let's go to the next slide, Deborah. For those of you who voted directly and you received the ballot yourself, you could either reuse the ballot that you have, if you still have the blank ballot or the form that you received, or you can email Omni, and we'll get to the Omni website here, and ask for a new ballot, and they will email you a new ballot. And so again, it's the same thing. You mark to accept, or reject, whatever it is that you want to do. We're encouraging everybody to vote to accept. If you want to elect for the 3,500 distribution and you did it before, you could do it now. Or if you did it before and you want to undo it, you could undo it and you just don't check that box now. If you don't know if you have any of the other claims of the other released parties, you just check out the opt-out box and make sure that you fill in all the information on the ballot, your name and your address, the last 4 digits of your social, and you sign and you date it, and you make sure that it's going to be received by Omni by 4 p.m. Eastern on March 4th. So let's go to the next one here. And so here's the information. All this information will be on the ballot, where you send it. And there also is the website there on the bottom there, because you could also scan your ballot, fill it out, scan it, and then upload it electronically through the web portal also. The next one here about some questions. If you have questions, to the extent that they're not legal questions, but they're sort of informational questions about, hey, can you help me get my ballot? Go to TCC questions at PSAJ Law. The BSA ballots at omniagent.com is the email address that you should use to get a new ballot. And there is the address again, where if you had to write them or ask them questions, and you could also submit online inquiries there at that bottom website address. But again, those two right there, those 2 email addresses are the most important. The bottom one there, BSA ballots at omniagent.com. That's how you get your new ballot if you don't have one ready and available. And if you're having some problems or you need some help, email us at tccquestions@pscjlaw.com, and we will connect you with somebody at Omni to get your ballot. And so when you're asking for your ballot, it's important to include your name, your date of birth, the claim number if you have it, and the last 4 digits of your social security number. All that information makes it much easier for Omni to identify who you are, and so they can make sure that they get your ballot with your claim number and your ballot ID number. You'd be surprised, there's more than one John Humphrey out there. There's more than one Doug Kennedy out there. And so there's a lot of names that you see that are the same. And it's important to give that personal identifying information so that they could be sure that they're getting you your claim number.
Thanks, John. Appreciate that. So I've been sort of picking some questions out. I can tell you that we are not going to get to everybody's questions tonight. We're well over 125 answered and over 125 still coming in. So lots of questions. We'll try to get those out and onto the site. But if I could pick a couple, and I'll just throw this out to the group. Why there's some insurers and counts and sponsored organizations that haven't settled. Why would an insurer settle now if they haven't had to already? What's the process there? You're muted, Rich.
I think the part of the issue related to what the plan looked like and moving forward to the confirmation. And as happens in most of these cases, as you get closer to the reality that there's confirmation and parties are getting out, that they're paying to get out, the pressure becomes more intense because it becomes much harder after the bankruptcy plan is confirmed. So one of the reasons we insisted on the veto right is because we want to avoid cheap settlements. A lot of the insurance companies actually were in negotiations because they wanted to get it done before confirmation of the plan. And we put a stop to that. There have been no settlements since we started negotiating. We would veto all bad settlements. And we think that at this point, the insurance companies, we are told, still want to settle in many cases, but without appropriate settlements, it will not happen.
And there also seems to be some confusion, but I know you outlined that we're going to put more information on the website on the various levels of review in the TDPs and in the trust in general. But it's more than just, hey, you got to pay a bunch of money to have that right. And I don't think people understand that these processes protect this pot of money for all survivors. So it's just not a penalty against survivors. This is so that the very best reviews go forward. Isn't that correct?
It's not only that, it's our best chance to get maximum dollars from the, particularly the excess insurance companies. Right now, and my numbers may be a little off, there are only 3 primaries left. The 2.7 million plus have come from the Boy Scouts, the local councils, at least a couple of charters, but the vast majority of the money is coming from the insurance companies. And those insurance companies that have settled, primarily settled based on primary. They may have some excess, but there are 3 primaries left. That money goes to the TDP. And there are about 17 excess, from small amounts to larger amounts. And none of those
what
have
excess
settled.
insurance is, real quick.
Excuse me?
Explain what excess
The
insurance.
excess insurance is that many times you'll get an insurance policy and it'll say the first $1 million of insurance will be paid by the primary insurance. You pay less insurance for excess because it's only for damages, for instance, above $1 million. And the excess carrier will always say, well, there's enough in the primary, so I don't have to pay. Excess carriers are notorious for fighting it because they know that there's a level of insurance that's ahead of them that has to pay it. And so the excess have tried to get out on the cheap. And what the independent review does is makes it more compelling for the excess insurance companies to actually settle out or ultimately pay if they don't settle out. And so the independent review is not just to help a particular group of survivors, it's to help all the survivors get excess, because 20% of all of the money that comes in excess goes into the TDP, which otherwise would never happen if we can't get that insurance.
Okay, great definition.
Yeah, it's worth reminding everybody too that the plan, a lot of these materials are posted on our website. There's a lot of questions about valuation and things, and that's on the plan as well. I don't know if we mentioned this already, John, but we're going to be putting together a video to explain in depth the different paths for review. I mean, it gets technical. It's very, very detailed. And rather than run through it in this meeting, I think we're going to do this in the next few days.
Yeah.
We're going to go ahead with some slides and run through the different levels of review, what costs are associated. And we think by having a video up, it'll allow people to just sort of stop, look at it, go back and forth, and really digest it. So give us a few days and we'll get something up on our website.
Yeah.
If I could just add to that, one of the things I didn't say that I should have said is one of the reasons I think we want to put the materials up, and we also want to take a little more time because it's a lot to digest, is I would very strongly recommend to each of you that has a lawyer to speak to that lawyer about this process. Many of the state court lawyers have been very much involved, and that's who should be telling you, because in terms of whether you should stay in the TDP or go into independent review, it's fairly complicated, and your lawyer should be the one who should be assessing that. And then we'll give general information about how the TDP and independent review, and as Doug said, the different levels of review on both. But it really is important for you to speak to your own lawyer about it.
So a couple of questions around timing, and one is specifically related to this. You know, we talked about this independent trust. How long before we find out, you know, who the members are, who the trustee is, who the, you know, claims representatives are? Is that how long does that process take?
Well, that's an interesting question. As of now, the independent trustee and the 2 claims reviewers, and there will be a huge staff beneath it to review all these claims, that is supposed to be disclosed to the court by tomorrow. If we had the information, John, we'd do it today, but I know there's been an interview process going on, and that is mandated by the court tomorrow.
And then, so I think this is 2 questions. One is, what happens now? I mean, is this deal done? What happens when it goes to the confirmation hearing? And then what happens after that? I mean, how long does it go to appeal, and how long does it take the trust to get set up? I think the root of the question is, when does the money start? The thing that Jim said like 2 years ago, how much am I going to get and when's the money start flowing? But I think people want to know what the mechanics are over the next several months.
Jim, I'm happy to do that if you want to.
I can do it, Rich.
Go ahead, Jim.
Okay, so the voting deadline is March 4th. And I just want to make clear to everyone, if you don't want to change your vote because you've already voted yes, you don't have to vote again. This is if you want to change your vote. Of course, as you can see from the backdrop behind John and Doug, if you've been listening, we recommend you change your vote. But if you don't want to change what you've done, you don't have to submit something again. So the deadline is March 4th. The Bankruptcy Court will start a hearing to confirm, or another way of putting it is to approve the plan on March 9th. The lawyers are still working out the lists of witnesses and the procedures for how the trial will be conducted, but it'll start on March 9th. It will be by Zoom. There will be no live attendance in the courtroom, and we will publish to all of you how you can attend the hearing. If you are represented by an attorney, Judge Silverstein has made clear that you cannot address the court except through counsel. Doesn't mean you can't attend, just means you can't speak to the court. She has not told us how she will handle people who are unrepresented, but the court knows who is and is not represented. So if you want to have your voice heard, it's going to be through the lawyer you hired. How long will that trial take? Well, there are betting pools going on about that, but I think we can expect it'll take no less than 2 weeks. Some people think it will take longer, but like I said, write to us and we'll tell you how you can be in the betting pool. Once the court has taken all the evidence and has heard the closing arguments of counsel, she will go back to chambers, reflect on the law, reflect on the evidence, and will write an opinion. How long that will take, no one knows, but it will take at least, I would think, 2 weeks. So we're at least a month out, probably closer to 6 weeks. That's my bet, from March 9th for the court to announce her decision. Once the court announces her decision, the U.S. District Court for the District of Delaware will be asked to also confirm/approve the plan. We'll have to see from the district court how much the court will entertain in terms of additional briefing and additional evidence. It will be, in effect, another bite at the apple. But I've heard from lawyers who practice in Delaware all the time that the district courts do take these, if you will, affirmation orders, that's what it's called in the Boy Scout plan, very seriously. It is important, but typically it's at least a month for the district court to decide if it's also going to confirm the plan. If both confirm the plan, if there are still objecting parties, they have the right to appeal the confirmation order, the approval order, to the Third Circuit Court of Appeals. But that does not mean that the plan can still not go effective, which is all of the gears kind of going into place. Some people's money will not be payable in its entirety until the plan has a final order with no appeal pending. It's not that there'll be no money coming in, but the totality of the money, some of it will be tied up if there are appeals. And we'll be urging the district court to affirm the bankruptcy court's order. And there won't be another voting process. It's just going to be the lawyers going to the court in the district court asking for approval. And we will also be urging confirmation if there is an appeal to the Third Circuit Court of Appeals. Again, no revoting, just legal argument. Once the trust is up and running, I would hope that the $3,500 expedited payment would in fact be expedited. And that there are some requirements even for the expedited payment. You have to sign the claim form yourself. You have to make sure it's substantially completed. But I would hope that from the time you've done that to your check, I mean, this is my hope, would be 90 to 120 days. Again, that's if you got your paperwork in. As to when the money will start flowing based on trust distribution procedure valuations or the independent review valuations, honestly, I don't think anyone could predict that with enough accuracy to start putting dates out there. I think it would be unfair to survivors to say, oh, you'll get it by the end of 2022. It's just too hard to tell, given all the things that will have to happen for the full amount of the funding to be deposited with the settlement trust. So Rich, that's my best timeline, and happy for you or John Lucas to amend, supplement.
Well, I do want to make one comment, Jim, and I think for a lot of survivors, there's a feeling of, okay, something has now happened. What do I have to do next? When's my deadline? Am I going to miss a deadline? And for sure, the TCC is going to be posting any of those dates that are going to be coming up. And then we're going to make it clear to the trust, there has to be the same level of communication, a way for people to know what's coming up. So they'll just sort of reduce that level of stress. So we're still in, let us get to the confirmation hearing mode right now.
So right now, with your red marker in your calendar, March 4th. And if you're gluttons for punishment, March 9th. And then draw a line for the next 2 weeks. Doug, one of the things
and March 4th is the new voting deadline, and then March 9th will be the confirmation
hearing. Yeah, one of the things Doug, you and I didn't talk about was, we love acronyms in this case, SASAC, the Sexual Abuse Survivors Advisory Committee. Separate from the advisory committee to the trustee, the plan provides for, I believe it's a 6-member survivor committee. I think it's 6.
I wanted to say 5.
5 or 6. Just survivors who will attend to survive, making sure the stack and the trustee don't lose sight of what's important to survivors. Now, of course, they won't, but there is a separate entity of just survivors, not run by plaintiffs' lawyers, not run by the bankruptcy lawyers, just survivors who will be making sure everyone remembers what this case is about.
Yeah, and we've also spoken too about getting the members of the STAC, the Trust Advisory Committee, on one of these meetings so that survivors can be introduced to who they are too, and have some confidence in them. But Jim, you make a really good point, and that is the survivors are still going to be paying attention formally to trust operations.
Right.
Yeah. Hey, I saw another question, and it had to do with sort of a plan type question, and I saw it more than one time. People were asking, can you please explain in sort of clear sort of details what it means to have a claim before 1976 and after 1976, and what are the consequences? And so do you want me to do that?
Well, John, I want to remind the 5 of us and the audience that some of these provisions in the plan are detailed. You're hearing us, you're speaking it to you. You don't have something to study, but you'll get something to study. So with that, John, please go ahead. Yeah. But I want to make sure that everyone knows that you will have resource materials on our website so that you can see in clear language what some of these distinctions mean, including the one you referenced.
Yeah. So those survivors that have claims against chartered organizations that arise January 1st of 1976 through the petition date, those claims are all being channeled to the trust. They're for the most part covered under the Boy Scouts common insurance. And for that reason, they are sort of channeled to the trust in that sort of lump sum fashion. For claims that arose prior to 1976, they're only channeled to the trust to the extent that there's an independent policy that was issued to a chartered organization by a settling insurance carrier. Otherwise, the claim prior to 1976 is still out there, and you could have it liquidated under the TDP and under all those processes, or after the expiration of 12 months after the plan goes effective, you could sue that chartered organization if it hasn't settled. So I think that's just sort of the most sort of simple way to look at it. And I realize it's technical, but we, as Jim and Rich and everybody said, you know, as we move forward here, we'll get more and more materials on our website to walk people through these tough questions.
And I will tell you guys, you know, I've read a lot of these term sheets and I've read more legal documents in the last 2 years. It will make your head explode, which is probably why we asked you to get counsel, to give you advice. And it's still not too late to do that. Doug, you have anything else in closing before we wrap up tonight?
No, just thanks to our folks. Thanks to all survivors for just hanging in there. We know this is tough. We're trying to do our best job to educate. These questions inform us. We're going to try and get to work on that video very, very soon. And as Jim mentioned, if you want to change your vote, and we're hoping that anyone that voted no, we're recommending to accept now. That March 4th is the deadline on that. And I think we're anticipating being back next Thursday. Is that correct, John?
I think so, yeah. So look,
John, I'm sorry.
Yep.
And just, you know, fine point on it. March 4th, 4 p.m. Eastern.
it has
4
to be
p.m.
in their
Eastern.
hand by 4 o'clock in the afternoon,
Yeah.
Eastern Standard Time.
So if you're using snail mail, remember it's called snail mail for a reason.
Yeah, you know, I don't think if I was going to mail it, I'd use snail mail, folks. I'd spend the money on FedEx or UPS. But wrapping up tonight, just want you to know that we appreciate your support. It's been a long haul. We're where we wanted to be. We knew we were the little guy in the fight, and we got a chance to get back at the table. And so we think this plan is something that you all should support, but you should talk to your attorney about it. And go to the TCC BSA website if you have any questions. The TCC questions at pszjlaw.com is always there. Remember that the voting deadline is March 4th, 2022. Keep looking at the site and look for the schedule for our next town hall, which we think is going to be next Thursday. So thanks, everybody. Have a great evening and a great weekend. Take care.
Stay strong, everyone.
Good night.